This is our second video discussing agreed upon remedies. This video will talk about when you can have a limitation on remedies clause, which will limit the remedy that someone can get from you when they breach a contract in certain situations. The case that explained what are the requirements to have a valid limitation on remedies was the Children's Surgical Foundations case. In this case, we had parties who entered a contract where the defendant would provide a variety of services, including billing and data processing. But then throughout the relationship, P claimed that D breached the contract by failing to properly code claims, post payments, and timely bill patients and payers, which caused damages in excess of $6 million. So a lot of damages. The contract contained a limitation on remedies clause that stated the company's liability, so the defendant's liability for any loss or damage arising from any cause whatsoever, will be limited to the total amount billed or billable to the client or company's service in each billing period in which services that gave rise to the loss of damages were performed. The liability herein is established as a liquidated damage clause and as a limitation on liability and not as a penalty. So trying to meet those requirements we just talked about in our previous video to have a valid liquidated damages clause. Well, here, D is arguing this clause is valid, which means P's exclusive remedy is the amount it paid to D for D's services during the months in question and not P's lost profits that equaled over $6 million. P's counter argument was, well, this clause is unconscionable, so it should not be enforceable because it's just completely unfair. Well, the court disagreed with P and said, well, this is not unconscionable. It's actually valid, and agreed more with the defendant. What was the reasoning behind the court's holding that this clause is valid? Well, it said the clause was valid, and it's on page 831, because there was a commercial contract between sophisticated commercial entities on both sides. So there wasn't desperate bargaining power. And even though the plaintiff had no attorney in this case, the plaintiff should have known the risk involved before signing a contract that contained such a damage limitation clause. So they're saying that the plaintiff was sophisticated enough to understand the risks, that an attorney wasn't needed. And in this commercial setting, which is two businesses dealing with each other, allocation of risk among the parties are usually generally accepted by the courts. The courts don't want to have to micromanage every single commercial relationship. This is something for parties to freely contract into as private citizens or entities. Also, it might not be favorable to the plaintiff, but it is a fair agreement. It does provide a remedy. It doesn't say there's no remedy. And the remedy that's provided is a minimum adequate remedy, according to the court. So the plaintiff will still get a remedy for the failed services, but it's not going to be able to recover all those consequential losses of lost profits over an unlimited amount of time. So here we have a clause that is valid, not unconscionable, and so the plaintiff's not giving up yet. The plaintiff says, well, if we enforce this limitation, it would breach this implied covenant of good faith and fair dealing. And so the court again disagreed and said that this contract has no such implied duty. On page 833 is where the court explained why this duty didn't exist. It's because it's a commercial contract that has no special relationship. There's no fiduciary relationship that would give rise to this implied duty. And also the damage limitation clause does not relieve the company from the implied duty to perform with care and skill. So the defendant still has to perform its contract. It's not relieved from not performing at all, and it's only dealing with that period where the defendant's performance is falling below whatever standard they agreed upon. So it's a duty to perform with skill and care and reasonable expedience and faithfulness versus this implied covenant of good faith and fair dealing. So the implied covenant of good faith and fair dealing, which is in the negotiations of creating the contract, didn't exist, but the duty to actually execute the contract still exists, which is why the plaintiff's argument fails according to the court. So what's the main takeaways? Where does this implied covenant of good faith and fair dealing fit in your remedies attack plan? To be honest, it doesn't really fit. It's more dealing with underlying breach of contract issues or whether a contract is valid. So you're not going to be tested on any of these implied covenants. I just wanted to cover them because they showed up in the case and often cause confusion. But what you will be tested on is understanding the relationship between unconscionability, which is what we learned as an equitable defense before, and a damage limitation clause. And so the relationship is contracting parties can limit their liability and damages to a specific amount as long as the clause is not unconscionable. If you remember from earlier in the semester, we talked briefly about the different ways unconscionability can arise in these situations where you have illegal contracts, unconscionable contracts or terms, or, even though it's unconscionable, we're not going to enforce it, but it's also going to bar you from getting any equitable relief. That's where we started. This case is dealing narrowly with when a damage limitation clause is enforceable, and the rule is it's enforceable if it's not unconscionable. So it just needs to meet that low threshold. But how does unconscionability relate to how does unconscionability and a damage limitation clause relate to this whole concept of liquidated damages? Well, liquidated damage clause is a type of damage limitation clause that is examined with heightened scrutiny, specifically that four-element test we learned about. As for unconscionability, what do you do with the new unconscionability subrules? Because we had quite a few in this case. You could just add it to your attack plan and use it to help you do the analysis. As we talked about again in the beginning of the semester, sometimes subrules will help you make those inferences or really explain your reasoning. And also understanding the policy is important, which is these unconscionability, I guess, restrictions are to prevent oppression and unfair surprise. And courts will other consider these other factors when determining unconscionability, like the atmosphere, alternatives, bargaining power, whether it's illegal or against public policy, whether it's oppressive or unreasonable. But specifically, you can use things like overreaching or sharp practices when analyzing procedural unconscionability or ignorance. You can always also use substantive unconscionability for substantive unconscionability that there's no honest or fair person that would accept a contract on such terms. So all these sub rules are helping you to do that analysis that you'll need to do on an exam to explain whether procedural unconscionability existed or substantive unconscionability existed.